One of the questions we get during an estate planning consult often is this: is my house, is the family home going to have to go through probate? The answer to that is it all depends on how you own it and how you've set it up to pass to your loved ones. Hi, I'm Joel Beck, an estate planning and probate attorney with Peach State Wills and Trust in Lawrenceville, Georgia. And in today's video, we'll talk about how the house can be transferred either in probate or outside of probate. So there's really four options in transferring the house, and we'll just walk through those. The first one is you do nothing. You have no plan whatsoever. Then the state is going to impose a plan, and your assets, after the bills are paid, your assets are going to be transferred to your closest living relatives as determined by the laws of the state of Georgia, what the legislature says. So if you don't have a plan, they're going to impose one on you, and that will happen through the probate court process. Now, the second way to transfer a home would be using a will. You create a will, a last will and testament, and it says where you want things to go, and you may say, I want the house to go to this person or these people. Once you pass away, the will gets filed with the probate court, and we go through a probate court process to transfer your assets. But now, instead of the state saying where it's going to go after the bills are paid, you are getting to direct where it's going to go because you've got a will, you've got a plan that says it goes here. When we're going through that probate court process, though, even with a will, if you're in the metro Atlanta counties, probably count on a 10 to 12 month process from start to finish for your family to get through that probate process, get everything transferred and resolved. It's not simple and quick. There are other ways to transfer your house outside of probate, and that involve either using a revocable living trust or, in some cases, a transfer on death deed. So let's talk about a revocable living trust. Here, with a revocable living trust or an RLT, you set up a trust. It's really a container, a suitcase for your assets, and you put your house into the trust. That involves changing the deed so that it's owned by the trustee of your trust on behalf of the trust. Once the house is in the trust, if you pass away, the home does not go through probate because you did not own it. The trust did. Your successor trustee, the person who takes over the trust after you've passed away, they step in, they pay off your bills, and they distribute the assets to your loved ones based on what the trust says. But here, they do it privately and out of court on a much faster and easier, more efficient timeline because they're not having to run things through the probate court process. Another way to potentially avoid probate for the house is to use something called a transfer on death deed. Now, this is relatively new in Georgia. It just came into being in July of 2024. I'm filming this at the end of July 2025, so we've had it right at 13 months. The transfer on death deed, it's new, but we have seen it effective. It lets you file a deed that puts a beneficiary designation on your house. It gives you the ability to say that this person or these people will inherit my house upon my death. And then that's filed into the Click County land records. When you pass away, your beneficiaries file a claim affidavit into the land records with a copy of your death certificate, and they claim the property. They've got to do that within 9 months of your passing. And if they do that properly, then the house will pass to your beneficiaries without having to go through the probate court process. The transfer on death deed is a good idea, and it's a pretty workable solution in some situations, but not all, especially if you want to leave this to multiple people or you want to have the property sold and the assets divided among several people, then a revocable trust is probably going to be a better solution. Likewise, if you want to build in some contingencies, I want Jim to get the property, but if he has passed away, then I want it to go to Mary, but if she's passed away, then I want it to go to Susie, for example. If you've got a plan like that, we can't do that with a transfer on death deed. We can only name one level, the first level of beneficiaries under the current law. Now, that law might change in the future, but as of today, that's what we have. So in some situations, the transfer on death deed is a good idea. It would be a workable solution, but it's not going to be right in every situation, including where you've got young beneficiaries, minors who can't really take the property, they can't take care of it, they can't legally own it, they can't contract, things like that. So we would look to find really what's the ideal way to accomplish your particular goals, given your wishes and the age and capacity of those that you want to take care of. So hopefully you've got a sense of really the 4 ways that the house might pass to others. There is a fifth, but we don't recommend it from an estate planning perspective. The fifth way is you can put somebody on the deed as a joint owner. That's not an estate plan. That's just making a gift during your lifetime, and it can cause some problems. Initially, your beneficiary is going to be typically in a much worse tax situation if they're added to the deed during your lifetime as opposed to simply inheriting it. And then in addition, once you add them to the deed, that house is subject to their risk. So if they have a lot of creditors, if they get sued and have judgments, your house is potentially on the hook for their liabilities, their bad decisions. So estate planners, we're never going to recommend that as a general rule, you just add an adult child or somebody else to the deed simply to avoid probate. It's bad for them financially, and it can be very risky for you as well. The other 4 ways are ways that we generally see that happen. And our preference in most situations, though, is going to be find a way to avoid probate to make things as simple and easy on your family as we can. Now, if you want to get more information about estate planning, find out what that looks like, get more information on these tools that we've talked about, revocable trust and wills and TOD deeds, download our free guide to estate planning, no strings attached. Just go to peachstatewills.com, click on free info at the top, and then select estate planning resources. Download that guide today, and then if we can be of help, don't hesitate to reach out to us. Thanks.